Welcome to Karma Kartavyam classes. Today, we'll be continuing with the topic that is fundamental rights. We'll be continuing with the topic that is fundamental rights. Now, in the previous video, what we have seen is what rights are, how they are important to an human being, and how does the United Nations Declaration of Human Rights come into picture after World War II. What are the circumstances under which our framers of Indian Constitution worked, and why they uh, felt that it is important to include fundamental rights as a chapter, as a part, which is part 3 in our Constitution. This is what we have seen in the previous video. You can watch the video if you have to understand further. Okay, so we'll start with the session. Now, what we have seen, let us start with this slide, which was the last slide of the previous video. Now here we can see a boy who is very angry at me and asking me to come to the topic. Topic pe aa jao. What was the topic? Our topic was fundamental rights. I explained. I took 18 minutes to explain what rights are, because as I told you, it will be a mechanical way of learning if we jump directly to part 3 of our constitution, that is fundamental rights. Now we'll start with this slide. I'm coming to the topic, sorry. So fundamental rights. So fundamental rights, what are they meant for? They are meant for promoting ideal of political democracy. Whenever someone asks you what fundamental right does, so what will you tell? They promote ideal of which democracy? Political democracy. Not, we are not talking about the economic part, we are not talking about the social part, we are only talking about the political parts. Fundamental right talks about political part of the democracy. It will promote the ideal of it will promote the ideal of political democracy, and it will prevent. What it does, it promotes, and second, it prevents. Now what does it prevents? See, uh, it will prevent authoritarian and despotic rule. As I told you, what is authoritarian and despotic rule? Whenever power becomes absolute, the rule become whenever power become absolute whenever power become absolute, the rule become authoritarian. The rule is what? Authoritarian. What do we mean by that? When power is absolute, the ruler or the government, whoever is governing us, that body will have all the power to take whatever decisions they want and whatever laws they need to frame. Therefore, what will happen? The rule will be authoritarian, and that will not be in the it will not be for the good of the people. Therefore, that kind of authoritarian rule, despotic rule, should be prevented, and fundamental right helps to do that. Or not helps, it confirms to do that. What? Prevent. Which rule? Despotic and authoritarian rule. Now, as I told you in the previous video, what we have 3 pillars. Which pillars? 3 pillars. What are those 3 pillars? Let me write here. These 3 pillars are legislature, 3 pillars of governance: legislature, executive, and judiciary. Executive and judiciary. Executive and judiciary. Fundamental right does impose some negative obligations on these 3 pillars. Negative obligations on these 3 pillars. In some cases, there are some articles which also impose some obligation on judiciary also, but then mostly the negative obligations are imposed on legislature and executive. Why are they imposed? Because they have to limit. What they have to limit? They have to limit arbitrary laws formed by the legislature, limit the arbitrary laws formed by the legislature, and tyranny of executive. Executive will have powers, right? Executive will have powers. That powers might be misused. By the executive, right? Now, when the powers are misused by the executive, that condition is called tyranny of the executive. To prevent that tyranny or misuse of powers by the executive, fundamental rights helps to do that. And also arbitrary laws, sometimes arbitrary laws are framed by the legislature. Arbitrary laws means the laws which are profitable, or else they are good or profitable for government only, not for the people, only for government or some group of people, not for the whole population. Therefore, these laws are called arbitrary laws. Now, to prevent that also, to limit that also, fundamental right helps us. And as I told you, there are negative obligations on the state. We have already seen what are the negative obligations on the state. What do you mean by the state also? So there are negative obligations on the state not to interfere. Negative means the fundamental rights always say state cannot do this, state cannot do that. What it cannot do, in a nutshell, it cannot interfere with the liberty. What it cannot do, it cannot interfere with the liberty of an individual. It cannot interfere with the liberty of an individual, and it aims at establishing a government of laws and not of men. Men means authority, authoritarian rule. No authoritarian rule. It will go by the laws, and the laws will not be arbitrary. And the executive of tyranny of the executive will not be tolerated. This is what fundamental right does, and this is what the importance of the fundamental rights is. Now, when we come to rights, there are different types of rights. What are those rights? There are constitutional rights. There are constitutional rights, and also there are non-constitutional rights. They are non-constitutional rights. Constitutional rights are the rights which are mentioned in the constitution. Where they are mentioned? They are mentioned in the constitution. Mentioned in the constitution itself. The framers of the constitution, what they ensured that some of the rights are included in the constitution. These are called constitutional rights. Some rights are not constitutional. That means somewhere they have to be mentioned, right? Where they are mentioned, they are given to the individual by making some laws by the legislature. By the legislature. By the legislature. This type of rights are called what? These types of rights are called statutory rights. Statutory rights. They are called statutory rights. So in constitutional rights also we have two types of rights. Let us WRIT here. That means let us write here. What are the constitutional rights now? The constitutional rights are fundamental rights. One type, fundamental rights, which are mentioned in part 3, and other constitutional rights. Other constitutional rights. That means what? They are mentioned somewhere else, not in part 3. They are mentioned somewhere else inside the constitution itself. So there are constitutional rights. So constitutional rights, in constitutional right we have two types of rights, fundamental and other constitutional rights, and we have statutory rights. So what are fundamental rights? We have seen whatever is mentioned in part 3 is called fundamental rights, and other constitutional rights are right to property, which is mentioned in Article 300A. Right to property once was a fundamental right in Article 31, but it was deleted and it was included in Article 300A, okay, and Article 301. Now, right to transfer property, right to marry, Manrega, and right to information. What are these rights? RTI, right to information, right to marry, right to information, right to marry, right to transfer property. These are all the rights which are given to the individual by making some laws by the parliament. So these are called statutory rights. What are these called? These are statutory rights. As you can see in this picture, what is happening here? This person is saying, what is saying? Let us go fast. That means what? Public has asked some information to this person. So he's telling that we have to give this information fast. So because it is a fundamental right. So this person who is assistant, which person? This person who is assistant of this man, he says, no sir, right to information is not fundamental right. It is statutory right. You have to remember, right to information. This can be asked in prelims or else any state PCS. So it is right to information is which type of right? It is statutory right. It is statutory right, not a fundamental right. See, right to marry is right to marry is a statutory right. Right to marry is a statutory right, but right to marry a person of your own choice is fundamental right under Article 21. Try to understand this. Both are different things. Right to marry. Let us mention somewhere. Let us mention here. Right to marry. Now, right to marry is which type of right? It is a statutory right. But right to marry a person of one's own choice. A person of one's own choice. This is which type of right? This is which type of right? This is fundamental right under Article 21. This you have to remember. This you have to remember. So this was about types of rights. Now, what is the situation of fundamental rights or rights around the world? So what we have taken is, we have taken three examples of countries. First is England. What is situation in England? What is situation in United States? And what is the situation in India? Now let us understand the political. See, the situation in England is what? In England, rights are not codified. They are not codified. Codified means what? They are not mentioned anywhere. But then it doesn't mean that English people don't have rights. They have all the rights, and they have right to do anything and everything, unless and until that act does not violate, sorry, that act does not violate any ordinary law of the land. Does not violate any ordinary law of the land. That means what? This ordinary law of the land is important for England. Important for England. That means what? It is important for England means, important for England means who make laws? Parliament make laws. Parliament of England make laws. So that Parliament made law, and this law is sarvopari. This law is सर्वोपरि. सॉरी फॉर द स्पेलिंग मिस्टेक्स इन हिंदी, बट सर्वोपरि. सर्वोपरि मतलब क्या है? जो भी लॉ पार्लियामेंट बनाता है, पार्लियामेंट, इंग्लैंड का पार्लियामेंट कुछ भी बना सकता है, कोई भी लॉ बना सकता है, वो लॉ सर्वोपरि है, एंड द एग्जीक्यूटिव हैज टू इम्प्लीमेंट इट. जुडिशियरी cannot review those laws. Court are what? Courts are powerless. Courts are powerless against the legislative aggression. Parliament can make any laws. Parliament means legislature. Legislature can make any laws, but they have some power against the executive, but not against legislature, right? In England, what is the situation? The situation is the laws are not codified, first thing, and fundamental rights are not codified. Second thing is law is supreme. Law is supreme. Law is supreme. That means legislature is powerful. Legislature is powerful, and judiciary is powerless. Powerless. Powerless against what? Powerless compared to against legislature. It does not have any power against legislature, right? That means what? There is no what you can say, no power to the judiciary to interfere with no power to interfere with what? No power to interfere with framing of laws. Whatever law has been passed, it is passed. No power. Understood? Now, what is the situation in United States? You have to remember, in case of United States, judicial supremacy is there. Judicial supremacy is there. Here, whose supremacy is there? Legislature supremacy. Supremacy of legislature. Supremacy of legislature. समझने की कोशिश करो, यहाँ पे कौन सर्वोपरि है? लॉ सर्वोपरि है, लेजिस्लेचर सर्वोपरि है. यहाँ पे लॉ के साथ कोई छिड़कानी नहीं हो सकती. इंग्लैंड में लॉ बन गया, बट यूनाइटेड स्टेट्स this is not the case. Who is powerful? Judiciary is powerful. There is judicial supremacy. There is no law which judiciary cannot review. There is no law. That means what? Let us write in a positive way. Every law can be challenged. And what? And judiciary can overturn it. That means both legislature as well as executives are kept in check. They are kept in check. Check means what? They are checked whether they are interfering with the liberty of the individual or not. Why it is so? Because United States was formed by the people itself, right? If you go back to the world history, United States, where the people live now, those are not native people. They are people from Australia. They are people from US, France. Every one of them came and settled there, and there were revolution. American Revolution was there. Then they formed their own country. The people from outside came and they formed their own country there. So that country was called as United States of America. Now, different states in that countries, United States of America. United States of America means states are being united. There is a kind of understanding between the states. States are not states are not destructible. They have their own identity. They have their own laws, not like India. In India, states are destructible. That means what? We can form any number of states whenever we want. But their states are permanent. They have some kind of contract between them and they form a central government there. Did you understand? And while the American Revolution took place, it was all on the basis of individual rights itself. Therefore, while framing the constitution, what happened? While framing the constitution, the individual rights were kept at the top, and according to that, laws were framed. Therefore, the individual rights are very important in USA. So everything is permitted now. Even carrying arms is also licensed arms. License are given. Arms can be, you can keep arms. Arms is what? Revolver, gun, AK-47, whatever you want, you can keep it for your self-defense. That is your right. That right is not absolute in India. You cannot just carry your any arms. Because of carrying arms, there are problems of shooting. Every now and then you can listen to the news. You can see that one boy aged 15, 14 took a gun and is shooting. He entered the school and started shooting the kids there. Every now and then you can see the news from there, because there individually right is being given that you can carry arms. So if you give that kind of rights to the people, that is also not good. That we'll see in the coming classes. So just keep in mind that individual rights in USA are kept at top. According to that, laws are framed. So you cannot in any of the case interfere with the individual rights of the people. If you do so, that person can go to court, and judiciary, if it finds that a particular law is infringing the rights of the people, then it can straight away overturn it. The law can be cancelled. Understood? So judicial supremacy is there. But that is not the case with Britain. Britain was a kingdom, and whatever laws are made by the parliament, that laws are kept at top now. Individual rights are not taken into consideration because their civilization, or else the rights were given. The individual is being prized now. Prize means what? What you can say? Individual rights are respected, but until and unless that individual rights does not interfere with the laws. If you follow the laws of the country, the laws framed by the parliament of that country, unless until you follow that, you are not disturbed. You can do anything, but you cannot infringe the laws. This is what the situation in England is. And court cannot do anything. An individual cannot challenge the laws made by the parliament in England and go to court. Court does not have power. He can go against executive, but not against parliament. Did you understand the situation in both the countries, England as well as United States? Now, what is the condition in India now? See, India became independent in 1947, right? In this year. Now, when it became independent, all the concepts were clearly established. That means what? Concepts were clearly established. That means what? Capitalism, socialism, democracy. Every concept was clearly established because there were many events in the world history that framed this concept. So India had many things in front of its eyes. That means framers of the constitution had everything in front of their eyes, and they could take bits and pieces from every constitution. That means it looked at England. There they saw that parliament was supreme. That is also not good. It will affect the people. In USA, they saw that judiciary is supreme. That is also not good. They are both extreme now. Individual rights are fully, it depends on individual rights itself in USA. That is also not good. So what India did was, not only in this case, in every case, India tried to strike a balance. So what it did, in India, the situation is, there is power of judiciary. Judiciary is powerful, right? It can review. It can review the laws made by the legislature. Okay, it can review the laws made by the legislature. But legislature also have some powers. What are those powers? It can amend the constitution. Whatever judgment Supreme Court gives, it will amend the constitution so that that judgment does not affect their laws. Right? That balance is there. Right? So let us read this. In India, power of judiciary vis-a-vis legislature is weak. Right? If we compare the powers of legislature and judiciary, it is weak. They can review and they can give their judgments, but legislature have power according to article 368. It can amend the constitution. It can make sure that that judgment is not affecting their laws. So power to impose restriction on fundamental right is given to legislature by the constitution itself, and the judicial review is in the hands of judiciary to determine the reasonableness of the restriction imposed by the legislature. This means what? This means we have rights. As USA, we have rights. We have right to speak, we have right to assemble, but then it comes with some restriction. Reasonable restrictions will be there. Restriction should be reasonable. That reasonableness is reviewed by the judiciary. Okay, that reasonableness is reviewed by the judiciary. Let me make it clear again. See, the constitution itself says that legislature fundamental rights are not absolute. Constitution itself says that every fundamental rights comes with some restriction. It is not freely given to the citizens. For example, if right to speech is there, it doesn't mean that you can say anything about anyone, because it will infringe the right of other. Your right will infringe the right of other individual. If you have right to speak anything, then you can speak any ill of anyone. No, you cannot do that. His right is there. Right of dignity is there with him, and that right of dignity will stop you from saying ill of him. आप हिंदी में अगर समझाया जाए तो हम यही कह सकते हैं, आपके पास राइट है कि आप कुछ भी बोल सकते हो, अपने आप को एक्सप्रेस कर सकते हो. इसका मतलब ये नहीं दूसरों के बारे में आप कुछ भी उसकी बदनामी करो. उसके पास भी राइट है, राइट ऑफ डिग्निटी है, अपनी बदनामी के खिलाफ वो आवाज उठा सकता है. So there is reasonable restriction. You cannot make a statement which is derogatory. So the restriction is there, and that restriction is reasonable. That will be reviewed by the judiciary. Okay. Therefore, we can conclude that as in England, the legislature has more power compared to judiciary. As in USA, judiciary has more power compared to legislature. But in India, there is a balance. There is a balance. If we compare the powers of judiciary and legislature, judiciary somewhat becomes weak. Judiciary power is weak. Judiciary is weaker than legislature. But having said so, it can review its laws made by the legislature. Okay, this is what the situation is. Now coming to the constitution and starting with the articles, the first article of part 3 is article 12. First article of the part 3 is article 12. As I told you, while we were discussing, we discussed that fundamental rights poses a negative obligation. What negative obligation we are talking about? Negative obligation on whom? Negative obligations are imposed on the state. Now it is very important to define the state. Now in every article of part 3, you'll see that some obligations are being imposed on the state. So state comes into picture every now and then. So we have to define the state. So article 12 does that, right? Article 12 does that. Now what article 12 says is the state includes, what does it include? It includes the government, parliament, government and the parliament. Government is executive, right? Parliament is legislature. Government and legislature of each states also. That means what? It is center. Government and parliament, that is of center. This is of state. And all local means panchayats, municipal corporation and all, and other authorities within the territory of India or under the control of government of India. Now everything was okay. When we read the article 12, article 12 is very clear what the state is, but there was some doubt where, okay, when we read the article 12, it says the state means what? Government of where? Which government? Government of India, government of states. State means Parliament also, and state legislature also, government at the center and government at the state, parliament at the center and legislature at the state level. They form state, they comes under state. And also all the local authorities that we see, panchayats, municipal corporation, they also come under states. But there was one word, other authorities. What does this other authority means? So there were cases, right? There were cases coming to Supreme Court challenging some body. Now, when that means what? For example, my fundamental rights are infringed. When my fundamental rights are infringed, I have right to go to Supreme Court directly or High Court directly under Article 32. That is what fundamental rights are. And I'm going against whom? I'm against state. Now I have to define what state is. If that particular body does not come under state, then I cannot go on directly to Supreme Court. This is the importance of defining a state. So the other authorities that is stated in the Constitution, Article 12, does not talks about, is very general. It is not very particular about the names of that other authorities. So there were doubts. So the cases came to Supreme Court. Why we are going to Supreme Court now? Supreme Court is ultimate interpreter. What is that? Supreme Court is, where is the cursor? Yes, here it is. So what is Supreme Court is? It is final interpreter of Constitution. Interpreter of Constitution means final interpreter of Constitution. That means what? There will be some words, some sentences which are very vague, and there are some many of them interpret in, many group of people interpret in different way. Government interprets in different way and try to make use of that clauses, that make use of those articles in good way also, bad way also, whatever it is. So it is the duty and it is the responsibility and it is the power, duty, responsibility and power of the Supreme Court to interpret that clause, interpret that article, and that interpretation of the Supreme Court is final. If it interpret that particular article, that interpretation, that meaning that Supreme Court gives you, that becomes final. And according to that, laws should be framed. Did you understand? That's why we are going to Supreme Court. The Supreme Court gives decisions. Now you will see that there were many decisions on this other authorities cases. What other authorities are? Supreme Court has defined it. But you'll see that Supreme Court has gone against its decision. Can it go? Yes. It can correct its own decision. For example, in one particular case, it have given some statements. It can contradict its own statements. In the next case, it can correct it. That power is there with the Supreme Court and High Court. It can correct their own decisions. That you have to keep in mind. What will keep in mind? Supreme Court is final interpreter of the Constitution, not High Court. Only Supreme Court. And Supreme Court and High Court can change their decisions, correct their decisions, you can say. Why we have to correct the decisions? Because society is evolving. So society is ever evolving. We were not the same in 1947, 1950s as we are in 2024. The situations are different. The societies are different. So according to the society's situations, the decisions are to be changed. The decisions which are taken by the Supreme Court today might not be relevant in the coming days. The coming days, the situations will be different. The people will be different. The generation will be different. So decisions have to be evolved that way. It cannot be, the Supreme Court cannot be adamant and say that this is the decision which will continue for eternity. It cannot be. That cannot be done. Society is evolving. So decision has to be changed. It has to evolve. Same-sex marriages are not allowed today. The decision of Supreme Court is that same-sex marriage cannot be allowed. But in coming days, these judgments can be changed according to the situations. So that it's just an example. Just keep in mind. So let's go to the judgments. What High Courts and Supreme Courts has to say about other authorities. Now the first case was of University of Madras versus Shantabai. That means what? See, we'll not go to the background of that cases, but we'll understand the crux. The crux is there was some issue. So a particular person, an individual, went to High Court stating that his or her, whatever, fundamental rights are being infringed. So first, court has to decide whether the body against which the person is framing the cases and coming to me under Article 32 is a state or not. So the question was whether University of Madras was state or not. So during this case, a term was introduced. During this case, a term was introduced. What was that term? Jusdem generis. What was that term? Jusdem generis. Jesdom generis means what? Of the same color. Of the same color. This judgment was given by Madras High Court. Of the same color. That means what? What does that mean? It means same color means, you can see in the previous slide we have seen that there were three bodies. There were some terminologies given in Article 12. It started with government and parliament, then government and legislature of the state, local and other authorities. Now this other authorities will be in same color means in same color as the other bodies that are being mentioned there. That means what? If it is government, it is parliament, government and legislature and local authorities. They are all, you can say, they are all bodies which are sovereign bodies which make laws. Is it no? Authorities also make laws. Local authorities make laws. They take care of the people there. So if other authorities also do the same thing, then they can be called as state. They should be of the same color. But University of Madras does not fit in those strata, in those lists. University of Madras is not sovereign and it does not make laws. It deal with the education part. So it is not a sovereign body. It is not a government as such. So University of Madras cannot be called as state. That was the judgment. By delivering the judgment, this is the term that the court gave. What is the term? Jesdom generis, of the same color. This was the first case. But in the next case, there are different cases. There are many cases, but we are taking only important cases. In the next case, that is in Ujjambai versus Uttar Pradesh, 1964. In Supreme Court rejected this Jesdom generis. Supreme Court rejected. High Court, Madras High Court has given this terminology, but this doctrine, we can say, Supreme Court rejected. Why did it reject it? Because this does not make sense. Supreme Court says that you cannot compare government at center with government of state. You cannot compare parliament with legislature. We cannot say that they are of same color. State is different, central government is different, state legislature is different, and parliament is different. Local authorities are different from state authorities. So they cannot be said to be in same color, in same pattern. They don't follow the same pattern. So that Jesdom generis does not hold good while deciding the other authorities issue. Supreme Court straight away rejected this doctrine. Now then came Electricity Board Rajasthan versus Mohanlal case. Electricity Board Rajasthan versus Mohanlal case in 1967. In this case, Supreme Court said that every authority which is created by the Constitution or any statute means any law, where powers are confirmed by that law, that particular authority can be called as what? That particular authority can be called as state. For example, let's say according to that law, any law, CBI is formed, CID is formed, or any body is formed, CBI, Central Bureau of Investigation is formed. That can be called as state because it's formed by the law, by the statute of the parliament. Now CBI is formed by law or not, that we have to check. So don't take that example, not CBI as such, but then we can say what is formed, any body which is formed by the statute, which is formed under the any law, ED, Enforcement Directorate. It is formed by the law, then it can be called as state. Okay. And Supreme Court also said that it is not necessary that a statutory authority that we are talking about should be engaged in some performing any governmental sovereign function. Governmental sovereign function means, what is the function of government? The basic function to govern people, to make any schemes that are beneficial for people, for governing the people. This is a sovereign body and it performs sovereign functions. If the body formed by the legislature or the law does not perform any sovereign function, then also it's okay. Still it will be called as state. As in Electricity Board, it does not perform any functions, any sovereign functions. It is a technical body. We take care of the Electricity Board will take care of transforming or transferring of electricity, but still it can be called as state. So there was some more cases were there. There was case of Sukhdev Singh versus Bhagat Ram. Now there were tests. We'll look about the what test Supreme Court finally arrived at while deciding other authorities, that you'll see in the coming slide. But for this slide, just keep in mind that in Sukhdev Singh versus Bhagat Ram case, Supreme Court has held that Oil and Natural Gas Commission, Life Insurance Corporation, and Industrial Finance Corporation are authorities within meaning of Article 12. That means what? They are state. That means what? They are state. Just remember the decisions. What to say? Remember the decisions here. Sukhdev Singh versus Bhagat Ram. Oil and Natural Gas Commission, Life Insurance Corporation, and Industrial Finance Corporation are called as, can be termed as state. Now here we are talking about some test laid, that we'll see what are the tests that Supreme Court laid, so to decide whether a particular body is state or not, that we'll see. But you remember here, Life Insurance Corporation, at least you have to remember this, Life Insurance Corporation, that is LIC, IFC, that is Industrial Finance Corporation, and Oil and Natural Gas Commissions are state. They comes under state. And in R.D. Shetty versus Airport Authority of India, that is AAI, in 1979, it stated something. See, these statements of Supreme Court or the judgments of Supreme Court are in the context. That means what? There is some situations at the background, and Supreme Court is giving this decision. Now the question was whether Airport Authority of India is state or not. Right? We're talking about state or not. So Supreme Court checked whether there is some governmental control over that authority or not. Governmental control means there can be shares. Decision of the government might affect that board. Government might be deciding the CEO of that board or members of that board. Some decisions of government, some part of decision of government might be affected, might be considered by that board. Some control is there, whatever percentage might it be, 0.1% also. Then that particular body can be called as state. मतलब क्या है, इस केस में सुप्रीम कोर्ट ने कहा कि थोड़ा सा भी 0.001 भी कंट्रोल अगर गवर्नमेंट का हो किसी भी बॉडी पे, तो वो बॉडी क्या कहलाएगी? स्टेट कहलाएगी. इस डेफिनेशन के हिसाब से एयरपोर्ट अथॉरिटी ऑफ इंडिया वाज डिक्लेयर्ड टू बी ए स्टेट. कंट्रोल और फाइनेंशियल असिस्टेंस भी, कोई भी फाइनेंशियल असिस्टेंस गवर्नमेंट के तरफ से इनको मिलता हो तो वो स्टेट कहलाएगा. दिस वाज द डिसीजन given by the Supreme Court in the case of R.D. Shetty versus Airport Authority of India. How many cases we have seen? First, University of Madras versus Shantabai, 1954. Now, why these cases are important? These cases are important because these cases or any cases of Supreme Court and High Court plays a role of masala in your so-called answer. When you are writing an answer, you have some masalas with you. You have to put, then your answer will be enriched, as if when you put a masala in curry, the curry get enriched with taste. Therefore, when you put masalas, when you put cases, when you put some judgments, when you put some case studies, when you put some reports means that report whatever it states that this particular group of people are being affected, this percentage group of children are being affected, that statement that when you put in your answer, then your answer will be enriched. So in that manner, this judgment will be important. You have to state it while you're writing the answers. That judgment are not random. That context should be there. When you're talking about state, you have to mention that judgments. So the judgments becomes important in that way. In prelims, that what they would ask, they'll not ask in the prelims that kind of small questions, but in PCS, in the state public services, they can ask that from the following, what can be called, which body can be called as state? LIC can it be called as state? Yes. In Sukhdev Singh versus Bhagat Ram, we have seen that Oil and Natural Gas Commission, Life Insurance Corporation, Industrial Finance Corporation are called as states. Yes. What was the first case? What in Madras High Court? What doctrine it gave? It gave jusdem generis. What is jusdem generis? Of same color. It said that whether if government of India, government of state, parliament of state, state legislature, they are of same color. They perform same functions, sovereign functions. If that functions are performed by that other authority, then it can be called a state. But in Ujjambai versus Uttar Pradesh, what Supreme Court said, it straight away cancelled. It did not give its. It rejected totally. It rejected. What it rejected? It rejected the decision, the doctrine actually. Which doctrine? Jusdem generis doctrine. It said that government of India and government of any state cannot be of same color. They are different. Central government is different from state government. State government is different from local authorities. So you cannot apply this doctrine while deciding the issue of other authorities. Then came the Electricity Board Rajasthan versus Mohanlal, 1967. What does it say? It says that any body which is made by constitution or any law, it can be termed as state. So we told that some tests are being laid that we'll see. According to that test, following all natural ONGC, LIC, and IFC were declared as state. In R.D. Shetty versus Airport Authority of India, in this judgment, Supreme Court said that even if a small percentage of involvement is of government is there in that body, then it can be called as state. Any financial assistance is provided by the government to that body, then it can be called as state. Then we're talking about some test laid. So in Ajay Hasya versus Khalid Mujib 1981 case, finally some tests were prescribed, right, to determine whether, according to Article 12, a body can be said as state or not. What are these tests? This test where we have to check whether there is any holding of the government in the share capital. Take LIC. Does government share is there? Yes or no? Yes, then it is called a state. How much financial assistance is being received by that body? Is the financial assistance more than particular percentage? Then it is called a state. Is the function of such nature in which the state had its monopoly? That means once the state had the monopoly in mining, state had the monopoly in banking, then it being transferred to other body, then that body can call as state. Then there is a deep and pervasive control of the state. That means what? Deep and pervasive control of state means the state or else the government controls that body, then it can be called as state. Then whether that particular body act as corporation, then it can be called as a body, as a state. Now any department of the government, once it was a department of the government, now it is transferred to a corporation, then it can be called as a state. So what does this point say? This 6 points say, they say that body is an instrument of the government. In some or the other way, the body that we're talking about is an instrument of the government. That is what it checks, right? The six tests. What does they check? They check whether the given body, the body in concern, is an instrument of the government or the state or not. If it is instrument means what? It is the government is using it. If it does, then that particular body can call as a state. Then there are in some many list of cases, you don't have to remember this, but you remember some bodies and whether they are states or not. So Food Corporation of India, we have seen in the last slide which are the bodies which are state, which can be called as state: LIC, ONGC, and IFC. And here FCI, Food Corporation of India, Steel Authority of India, SAIL, Steel Authority of India Limited, SAIL, Bihar State Electricity Board, Indian Oil Corporation are the states in the meaning of Article 12. Don't remember the judgments, but 2-3 judgments you have to remember. While you are writing the answer, it will be helpful. Then NCRT, this is important. Chandramohan versus NCRT. In Chandramohan versus NCRT, Supreme Court said that NCRT cannot be termed as state because it cannot be termed as state under Article 12, but because it do not have any role in governance as such. It is about education. It is about what? It is about education. Therefore, it cannot be termed as state. Now, in BCCI versus Cricket Association, BCS was not termed as state. BCCI is not a state. It's not a state. Because why it is not a state? Because it is a private body. It is a private body, and government does not have any share in it. And it does not government does not interfere also. Government has no share. It is purely a private body. And what is BCCI? It is Cricket Association, right? Which takes part in international competition, cricket competition, we can say. What is the term that I'm not able to remember? But international competition, World Cups, World Cup, Sahara Cup, right? It takes part. Okay. So BCCI versus State Constitution of Bihar and others was held that BCCI is not a state, but it is amenable to jurisdiction of High Court under Article 26. Article 32 is not, because if it is not a state, what will happen? Article 32 cannot be implemented. I cannot go to the court under Supreme Court under Article 32, but I can go to High Court under Article 226. We'll see what is Article 226 and Article 32 in the coming lectures. But you remember, under Article 226, I can go to High Court against BCCI. That you have to remember. So what we have seen, just remember this Article 12. Article 12 is about definition of state. First thing. Second thing is everything is clear, but one problem is there. What is the problem? That other authorities is very vague. The term other authorities is very vague. So there were many cases. So first case was University of Madras versus Shantabai. There Madras High Court gave a doctrine. Which doctrine? Doctrine of jusdem generis. Jusdem generis means of same color. They told that if other bodies that we are considering, whatever body we are considering, if it is same as that of government of central government, state government, same duties it does, then it will be a state. It was very vague, right? When Supreme Court heard about this, it said that how can we call that, how can we say that central government, state government, parliament and legislature, this municipal corporation, all are of same color. They deal with different territories. Central government deal with whole of the country. State deals with only one state. So they cannot be called as of same color. So it rejected that doctrine. Then electricity board versus Rajasthan versus Mohanlal. In that case, what Supreme Court told that any body which is constituted by the constitution itself or any statute, that means any law, then it can be called as a state. In Sukhdev Singh versus Bhagat Ram, what happened? Some bodies were declared as state. What are those bodies? Oil and natural gas, ONGC, life insurance and industrial finance corporation. Then R.D. Shetty versus Airport Authority of India. Airport Authority of India was declared as state because the government was involved in it. It said any government share in a particular body or financial assistance is given, a particular percentage of financial assistance is given by the government, then it can be called as state. So all this judgment, based on all these judgments, some tests were framed by the Supreme Court while deciding whether a particular body is state or not. What are those tests? We have to test whether the government has some share or not in that body. How much financial assistance is being provided by the government? Is the function that a particular body is functioning now, was it functioned by the state as a monopoly in the previous past? And whether there is a deep and pervasive control of state in a particular body and functions of whether a particular body act as corporation. This test should be performed. And if it finds that yes, it is, then the particular body can be called as state. As a nutshell, what this test do, this test try to find out whether the said body in the context acts as an instrument of government or not. If it acts as an instrument of the government, then it can be called as state. So this tests were coming under a doctrine was there. That means this can be called as doctrine of instrumentality. What is that? Doctrine of instrumentality. So there were some more cases, many more cases, but these cases are not so important. But you remember the body which are called state: FCI, Authority of India, Steel Authority of India, SAIL, Bihar State Electricity Board, Indian Oil Corporation, BCCI. They are BCCI is not a state. Indian Corporation is state. NCERT and BCCI are not state. But in BCCI, we cannot go to court against BCCI under Article 32, but under Article 226 we can. Okay. Now the question is judiciary considered as a state under Article 12? Yes, judiciary is considered as state or not? See, there are two contexts now. Judiciary cannot be a state under Article 12, but then while it is performing some administrative duties, then it can be considered as state. But when it's giving judgments and all, then it cannot be considered as state. Right? For example, when they are dealing with their administrative staff, and administrative staff has some issues with the court, then it can be called as or referred to as state. But when I have some problem with judiciary judgments, if I have to challenge the judgments, then they cannot be treated as state. There are two things: administrative purpose, they can be treated as state; judiciary can be treated as state. But judgment purposes, if you have to challenge judgments, it cannot be treated as state. Now, recent judgment in 2023, Supreme Court held that fundamental rights guaranteed under Article 19 and 21 respectively. That means what? We have fundamental rights from Article 14 to Article 35 or something. 32, 33, 34, 35. Yes. Now, Article 19 and Article 21 are very important rights. We'll come to know while we are reading about that rights. Article 19 and Article 21 are very important rights. And those rights, irrespective, if that rights are infringed, irrespective who is infringing it, whoever, whatever body it is, whatever, it can be individual also. I can go to court under Article 32. And those whoever it is, they will be treated as state itself under Article 12. Under Article 12, whenever my rights are infringed, which rights? Under Article 19 and Article 21, then whoever is infringing it, he will be called as, he will be referred to as, or it will be referred to as state. And under Article 32, I can directly go to Supreme Court. I hope you understood Article 12 clearly. So this session, we'll end this session here. I hope I am delivering well. If there are some issues with the video or issue with my explanation, I'll improve it. But just do watch. If you have any problem, do comment in the comment box. I'll read it and try to improve my teaching and the slides. Your feedback is mostly welcome. And I'll be posting many more videos. We'll complete this Indian polity. And I hope it will be helpful for you. Thank you.